Okay, when you're ready, sir.
Thank you to all of you for coming out tonight on a wet and windy December night, and particularly thank you to WP UK, who have done more for women's rights and for, as your t-shirt says, Sarah, bringing feminism back, than anything I've seen throughout my life. I feel privileged to have this opportunity to speak with all of you and to share a platform with these wonderful women. There are so many legal issues to discuss, and many things have already been said. Lots by Julian, lots that she's written, in case any of you haven't read it, and lots by many of the lawyers, some of whom are sitting in this room tonight undercover. I want to take a step back and focus not on the national law, which Julian's already covered, but think about the international human rights law framework within which women as a sex class are protected, and within which vulnerable groups are protected, and why this international human rights framework exists. And I will sort of go through that and then end with looking at some comparative law about how sex and gender identity are dealt with in different countries, because I think very many things are said without nuance and without facts, and are claimed to be true when they're not. We're seeing the use of human rights discourse. So is this microphone working?
Yes.
Or should I just, okay.
Yeah, it's distracting, isn't it?
We're seeing the use of human rights discourse, can you hear me at the back? I hate microphones, to promote the objectives of the transgender lobby.
It's better than nothing.
Stand up!
Woo! Okay, can you hear me at the back?
Yeah.
Marvellous. We're seeing the use of human rights discourse to protect and to promote the objectives of trans rights individuals and their lobby, even where doing so undermines the human rights of women. I want to explain a little bit about international human rights law, the specific protections that we have as women under those laws, and why that discourse is being used by the trans lobby. I also want to examine some of the key legal developments in relation to human rights of women and human rights of transgender individuals, both at the international level and in countries where gender self-identification has been introduced. International human rights law sprang from the ashes of Nazi Germany. At that time, there was no law that told a country how it could or could not behave towards its own citizens. International human rights law started because in Nazi Germany it was not unlawful for the government to kill or torture or discriminate or oppress gay people, Jewish people, Roma people, people with disabilities. The only laws that existed at that time governed how states behaved towards citizens of other countries. Now, while we all will know, I hope, in this room, that what happened in Nazi Germany from 1933 onwards was heinous and immoral, it was not unlawful. And the world got together after Nazi Germany, well, I say the world, 50-odd countries, many of whom were colonizers. Most of the 193 UN member states today were under colonial rule. They got together and said, this can never happen again. We need a set of laws that say that if you are born human, you have certain fundamental rights. Rights to protect you, the weak individual, against the big and strong and powerful government under which you live. And that led to the Universal Declaration of Human Rights, which is 70 years old this week.
Hey.
That Universal Declaration of Human Rights took 2 years to negotiate, and it came up with articles about our fundamental freedoms by virtue of being born human. And there was a great discussion at that time. Should we look at the individual vulnerabilities of groups like people with disabilities, children, women, racial minorities, or should we say that every person has these human rights by virtue of being born human, and we are idealistic, and we don't need to separate out those categories? And what was decided, thank you Eleanor Roosevelt, was that we will not think about those vulnerable groups and protected characteristics because we are idealists, we're lawyers. So we're all born with these rights by virtue of being born human, and we will all have them, which sounds great. Now, I tell my students that that Universal Declaration was not accepted by every country. That Universal Declaration was voted down by 8 countries, mostly communist states, for various reasons I won't go into tonight, but if any of you ever want to know, I'm very happy to give you a mini tutorial. But ultimately, that Universal Declaration talks about our rights as humans. Very quickly it became apparent that no matter how many states signed up to it, women were being discriminated against and oppressed by virtue of being women from the off. And there was a need to have a particular set of protections specifically aimed at women to allow political participation, education, the right to not get married off as a child, and all sorts of other rights that men were holding by virtue of being born human. And so, the UN Commission on the Status of Women sprang into action, much quicker, by the way, than the rest of the human rights system at the UN, and very quickly developed what became a declaration and then a treaty about the elimination of discrimination against women. In 1967, the UN Commission on the Status of Women took this groundbreaking step of adopting the declaration, followed in 1979 by the treaty on eliminating all forms of discrimination against women. And it created a mechanism to be able to monitor how states are doing on eliminating discrimination against women, a treaty body called CEDAW, which many of you will have heard of. The advancement of women's rights has continued with further groundbreaking moments. At the same time, and despite much focus on ending discrimination and advancing women's equality, and the increasing focus on violence against women and girls, we remain today, in 2018, 70 years after that Universal Declaration, in a world where women are subjugated, where they're denied their fundamental rights, both in law and practice, around the globe. The fight for women to have specific protections paved the way, as often happens, for many other vulnerable groups. And we now have specific protections for children, for persons with disabilities, for racial minorities, and so on. The very idea of having these specific protections for groups who face particular risk is no longer viewed as undermining this universal declaration, this idea that we're all born with fundamental rights. It's now viewed as seeking to uphold the fundamental rights of groups that experience marginalisation and vulnerability by virtue of how they were born. There's now a clear understanding that the risks faced by members of such groups mean that they require specific protections, both in law and in practice, both at the international level and at the national level. Although, of course, just because that understanding exists doesn't mean that it's translated into reality on the ground. But it gives us laws, human rights laws, that are tools for us to lobby for effective change on the ground. And those laws are important. In international human rights law, and I spoke to someone who has been very involved in this for many decades, although she won't want me to mention her name because it might out her age. In international human rights law, women has always been defined as biological sex. And so we've been going through some of the old records, summary records, for decades, about where women is defined as sex. And she said to me, Rosa, of course women is defined as the sex class. Everyone knows what we're talking about. So digging deep to find it has proved quite difficult, although not impossible, and we're writing a paper on it. That is mirrored in the national law, and the one bit of national law that Julian didn't mention, so I've scribbled down quickly, is the April Ashley case. The case of Corbett and Corbett. The case that my mother says I always have to explain to people because not everyone is old enough to remember it. But April Ashley was a very famous transsexual woman who married a man in high society, and this was at a time before Twitter, so the media, had to pick up a story and run with it for a while, and they didn't get distracted. And April Ashley and her husband, or her partner, who she'd married, couldn't consummate the marriage. So they went to court, they were trying to decide whether to get a divorce or an annulment. And the court looked into an annulment based on either he couldn't consummate the marriage or she wasn't a woman. And the court looked at the various different ways of defining sex. Also, if anyone's interested, it's not a very long case, and Press for Change very helpfully have the PDF up on their website, although they may not, the amount that I tweet about it, anymore. They also very helpfully look at the difference between intersex and transsexuals. And the judge in that case was a medical man who goes into the detail in a very engaging way, if any of you are bored this evening and want to read it. The court decided that sex is about biology. It's about chromosomes, it's about gonads, and it's about genitalia. That is basically what international human rights law says as well. And that case remains, I think, Julian, good law in this country. Now, gender has been defined in international law as social construct, based on the different way that two sexes are viewed and treated in societies. This includes laws and practices. So there are some forms of discrimination against women that might be based on their sex, for example, the denial of reproductive health rights, child brides, and so on. And there are some that might be based on gendered constructs, denying girls the right to education because, of course, they're not going to go out to work, or violence against women and girls based on gendered societies. The international human rights law framework and mechanisms focusing on women provide very specific protections for women to access their fundamental rights based on the long history of violence and discrimination against them based both on their sex and on gendered social constructs. Separately, in international human rights law, there have been attempts to protect sexual orientation and gender identity minorities. Now, I know people don't like this umbrella term, SOGI. Sexual orientation and gender identity minorities is the UN term for LGBTQ and so on. Right? It's a particular term of art rather than lumping everyone together in the way that I know does offend many people. Almost all of these attempts are done separately. Almost all of these attempts are done separately to the protection of women's rights. Sexual orientation and gender identity minorities are a separate vulnerable group, just as children are, just as persons with disabilities are, just as racial minorities are, and just as women are. Those attempts to protect sexual orientation and gender identity minorities, unfortunately, and deeply concerning, are blocked at the UN level by the 77 countries that still criminalise, discriminate against, or oppress, or condone private violence against LGBT persons. And many efforts to protect even the most fundamental rights of those people have failed as a result. Of course, every individual has fundamental rights by virtue of being born human, and those rights include non-discrimination and the right to dignity. The denial of fundamental rights to LGBT persons around the world should concern us all. And it is clear that there's a long fight ahead to protect those minorities, particularly in those 77 countries. So when the trans lobby frames access of transgender individuals to sex-segregated spaces as a human right, what it seems is that they want to create specific additional protections, like we have as women, like children have as children, like persons with disabilities have as persons with disabilities. To do so, they would need to have a formal legal human rights recognition of what gender identity means. And what that gender identity, as Julian said, is in terms of a protected characteristic and a vulnerable group. Now, I say all this as a way of background to understanding why the trans lobby first is framing this as a human rights issue and why they're seeking to merge sex and gender, or sex and gender identity. Because they want to take our hard-won rights as women, because there is a long and tough battle that I think we all, together in this room, with everyone outside this room, even those who are protesting, need to fight together to protect gender identity minorities, not as the same as women, not as the same as sex, but as a vulnerable group who are having their fundamental rights denied to them. Gender identity and sex are two separate things, both in law and in fact. Sex has been defined and protected in international human rights law, and gender identity is at a very early stage, both in terms of definitions and in terms of protections. The idea that self-identifying one's gender, note that you can self-identify your gender but not your sex, has some support in international human rights law, not much, but embryonic support. The European Court of Human Rights has stated that the right to a private and family life, as Julian has said, includes something called the right to self-determine one's gender, but they haven't explained what that means. There are, I can never pronounce it, the Yogyakarta principles, created by a group of international human rights law experts that talk about self-identification of gender, again, not of sex, as being key to trans people's ability to realise their fundamental rights, those rights to not be discriminated against, to not be tortured, to not be put into prison. Of course, in the international arena, that's nearly impossible. There is little likelihood of creating specific mechanisms to protect gender identity minorities, given that A, there is no clarity about what that means, and B, that 77 countries, like I keep saying, out of 193 UN member states, criminalise LGBT persons or discriminate against them in law. The Yogyakarta principles were created by a self-selecting group of human rights experts, which is how most human rights initiatives start, including the Human Rights Initiative on torture. What normally happens is that a group of experts get together, they discuss an issue, they produce a report, that report is then taken to NGOs, to states, to many people to debate and discuss, to take it up, to take it forward, to rewrite it, and eventually, if we're lucky, it might become law. That has not happened with those principles. Indeed, those principles have gained hardly any traction whatsoever. And this, I would say, leaves them pretty much dead in the water. There have been some occasions where they're referred to by academics, or even sometimes, rarely, by a court, but they're not referred to as soft law, they're not referred to as legal concepts, they're referred to as a report written by human rights experts, which sometimes I write a report that someone might refer to. Certainly doesn't make it law. I would hope not, anyway. But even in those principles, which are held out by the trans lobby group as being the holy grail, gender identity is not defined. The recent report by the UN Independent Expert on Violence and Discrimination against Sexual Orientation and Gender Identity Minorities in 2018, where he examines violence and discrimination against gender identity minorities, defines gender identity by referring to a version of Stonewall's umbrella term of transsexuals, transvestites, and all sorts of other people, but does not identify or give clarity about what gender identity actually means. This is not a definition for the purpose of law. Some laws have been passed in some countries about gender identity, again, none of which provides a definition. My favourite one's from Massachusetts, which says, and I'm paraphrasing, someone's gender identity is the gender with which a person identifies. Now, this all gives some background as to why the trans lobby is seeking to make changes on the ground in practice rather than in terms of law. Because to gain specific protections in international human rights law, they would need a definition of gender identity, and they would also need to have the buy-in of member states from the UN, both in terms of that protection and also in terms of the 77 countries who would like to carry on criminalising, torturing and oppressing gender identity minorities. Without being able to identify gender identity, they will never be able to get specific protections for this group. So, instead, what they would like to do is conflate gender identity and sex to take women's hard-won rights and specific protections that took decades to produce in order not to have to fight this battle. The proposed changes in this country that we've seen over the last year are in direct conflict with women's rights already established in law. And many times they're framed in terms of human rights. What I'm particularly concerned with is this idea of the human rights discourse being used about self-identification in other countries in terms of gender identity and sex. 6 years ago, the UK was one of a tiny minority of EU countries that did not require transgender people to have forced sterilisation before being given access to medical treatment. Those countries that required forced sterilisation included Denmark, France, Italy, the Netherlands, Norway, Portugal and Sweden. Even last year, when the European Court of Human Rights ruled that forced sterilisation is a human rights violation, EU countries including Belgium, Croatia, Czech Republic, Finland, Greece and Switzerland still had those laws in place. It's against this backdrop that we need to understand the many changes on legal recognition of transgender individuals and self-identification across EU countries. We keep being told that many other countries have self-identification without any problems. Many of those countries that introduced self-identification were the same countries that were trying to remedy the forced sterilisation and human rights violations that they've been perpetrating against trans individuals for decades. So let's start with Ireland. Until 2015, Ireland did not recognise transgenderism at all, and no individual could receive legal recognition of their preferred gender. Ireland now has laws for self-identification of gender, including for young people, without any requirements of having had a meaningful transition or having lived for a length of time in that gender. Ireland has also retained sex-based exemptions for a large number of areas, including schools and prisons. So the self-identification of gender seemingly has very little impact upon women's rights and sex-segregated spaces. The government is currently under some pressure to consider whether to have specific policies on sex and gender, but currently the practice is for each institution to make its own decisions, and those decisions are currently protecting sex segregation where it's proportionate and legitimate, including schools and prisons. In 2014, Denmark changed its laws as to how a person can change their gendered social security number. That change went from requiring medical treatment, including forced sterilisation, to being able to self-identify after a 6-month waiting period between registering and having lived in a meaningful way in the preferred gender. Those 6 months are called a period of reflection. This is not the same self-identification that we're being told that Denmark has. Denmark also has the option for an X gender on passports, which the Netherlands has, which means that many people who identify under the broad banner of non-binary, including, Julian, your favourite phrase, gender fuck, would be able to register in that way. Sorry, Mum. There are only 6 million people in Denmark, and women's rights and the women's movement is central to that society, yet there are already cases of violence against women and rape by self-identifying women who have accessed women's spaces, and the same is true of Norway. In Malta, self-identification allows trans women to access female prisons, but the law provides for separate showers and sleeping facilities and other facilities where people might be naked or vulnerable, and also for female guards in those prisons to be given a choice as to whether or not they search self-identifying trans women. I'm running out of time. I'm always running out of time. But I raise these issues because we keep being told that self-identification is fine elsewhere, that there are no issues, that sex-segregated spaces have just been erased, and these are not true. There are facts on the ground about countries like Argentina, which I don't want to emulate here, where there are female prisons and male prisons and LGBT prisons. People point to Pakistan in terms of self-identification, where gay individuals are coerced into transitioning, because if a person's attracted to another person of the same sex, then society assumes they must be trans. And in Iran, that's written into law. None of us have the answers, apart from Julian, as to what's going to happen next. But what's clear from international human rights law is that women's rights must be protected, and that the UK has a legal obligation to do so under international treaties. We've heard that in the UK, the relationship between the Gender Recognition Act and the Equality Act is such that it's not clear how sex-segregated exemptions might be retained, how frontline services might deal with these issues. We already know that many of those exemptions are being ignored in practice, partly because people are accused of being bigots or are worried about their funding sources. What we need is clarity, and I'll echo Julian on this. Clarity in terms of the law, clarity in terms of definitions. We need proposals for solutions that will uphold the rights and dignity that all human beings are afforded by virtue of being born human, including specific protections afforded in human rights law to vulnerable groups. But most of all, we need the UK to remember that it is party to international human rights treaties that require it to protect our sex-based rights, and that we will hold it to account if it refuses to do so.